Supreme Court ruled today on mail-in ballots based on that case out of Mississippi. Is the Save America Act in any trouble should it pass because of this ruling? Let's get to Greg Jarrett, Fox News legal analyst, former defense attorney and law professor, and author of some incredible books you can check out. Greg, it's a pleasure to have you on the show today after these rulings. Thanks for being here.
Good to be with you, Annie.
So talk to me a little bit about the Supreme Court ruling on that Mississippi case, what they determined about mail-in ballots, and then we'll get down the road to the Save America Act.
Well, this wasn't about ideology. It was a specific reading of existing federal law. And the court said that the federal statute specifies when voters must vote, but it doesn't say anything about when mail-in ballots must be received. So it is up to Congress, said the court, to pass such a law if they want ballots to be received by Election Day. And until then, states have the power to manage ballot counting, which is what Mississippi did in this case. It's entirely consistent with the Constitution. If you read the Elections Clause in the Constitution, it gives Congress the power to regulate federal elections, but states have the authority to administer them. And that includes everything from voter registration to polling locations, ballot design, and vote counting. So to your point about the Save America Act, I think this opinion by the nation's highest court incentivizes Congress to do what the Constitution tells them to do, write laws that regulate federal elections, and that's what the Save America Act does.
We're speaking with Greg Jarrett here. Now, what I hear you saying, if it were an activist court bench, Supreme Court bench, if they were activists, if they were in the back pocket of President Trump, it seemed like this would have been a really good opportunity for the Supreme Court to legislate from the bench and maybe put this into plan. But it seems as though we have a judicial branch that's saying, hey, legislative branch, your move, this is your responsibility, not ours.
Yeah, absolutely. And, for those who constantly accuse the Supreme Court of being in the bag for Trump, this is yet another example in which they're not. The Chief Justice, John Roberts, Amy Coney Barrett, Associate Justice, sided with the three liberals on the court and said there are limits here. And if you want something done about mail-in ballots, go across the street to the legislature. And, that's where the power resides pursuant to the Constitution.
Well, let's shift away from that Supreme Court ruling today. There were two other big ones that are being discussed largely, and they have to do with the executive authority to fire people who serve in the federal government. Can you give us the distinction between the two? Because it looks on the surface level for us non-legal eagles like, oh, you can fire those people, but you can't fire those people. What's the difference in these two cases that defined or refined executive authority?
Well, so on the one hand, the Supreme Court today in the so-called Slaughter case gave the president broad authority to fire leaders of federal regulatory agencies because they're exercising executive power, and they must report to the chief executive, the president, who controls those federal agencies, so he can unilaterally fire at will. But insofar as the Federal Reserve is concerned, the Supreme Court drew a constitutional and statutory line around the central bank. The majority said the president cannot fire a Fed governor without satisfying the standard in the Fed statute, which is for cause, and that includes giving Lisa Cook due process. And the court said, wait a minute here, we're not sure you really gave her due process. You just sort of said you're fired. You didn't give her a chance to respond. That's due process. So what the Supreme Court did was they created an exception for the Federal Reserve as opposed to these other regulatory agencies. And why did they do that? Well, the answer is simple, because in creating the Fed back in 1913, Congress structured it to operate independently because they recognize that monetary policy is meant to be protected from political pressure. Understand here that the court didn't say that a federal governor can never be fired, only that you got to meet the statutory standard of due process when you do it. It's as simple as that.
I want to shift gears because I know we have to let you go here in just a minute, but there are two cases that get a lot of play and discussion as far as funding midterms goes. I want to bring up George Soros and his son Alex Soros. New York Post reports here this weekend that they've funneled $103 million into the midterms so far. But today, from a Fox News report I'm reading on a different name that has been coming up lately, a federal grand jury is investigating alleged financial crimes by Neville Roy Singham, the China-based tech tycoon whose fortune has funded a sprawling network of socialist, communist, and Marxist organizations across the United States. They're suggesting that he's pumped $285 million from Shanghai into a philanthropy fund and some shell corporations that have found its way into some of these election processes. Can you speak to what the Department of Justice is looking into here, or where maybe you'd like them to look into here?
Well, they're being mysterious, so I can't say for sure what they're looking into. But look, we have pretty strict laws about foreign money, particularly through shell corporations, that go into U.S. businesses, nonprofits, as well as elections. And I can only suspect that they're investigating whether this was done properly or done in violation of law, particularly if it involves, supporting individuals who are engaging in unlawful activity. And often money laundering occurs during the course of that. So, you can't pay for criminal activity. And if that's what's been going on with Antifa and other organizations, then, that's going to be a problem for them. Mm-hmm. But, part of the problem is historically, all kinds of, tens of millions of dollars have been funneled into super PACs. And you don't always have to identify the donor, unlimited. I always thought that was a wrongful decision by the Supreme Court, Citizens United, and this may be one of the negative results that, I feared.
Yeah, I agree. Do we expect birthright citizenship ruling tomorrow?
Yeah, tomorrow's the last day. The Chief Justice has said that, so, that's a big one. Whether children born in the U.S. to non-citizens who are not legal residents are entitled to automatic birthright citizenship under the 14th Amendment. I have written columns arguing that if you go back to the debate when the authors of that provision in the 14th Amendment crafted it, they specifically said that this is not to apply to the equivalent of birthright citizenship. So, but I listened to the oral arguments, and that wasn't an emphatic argument. I think it should have been. I think the odds are against Trump on birthright citizenship.
Yeah, I that's what everybody seems to say, and you specifically. I encourage people to read what you've written about it. We will find out tomorrow. Greg Jarrett, always a pleasure to have you with us. Thanks for your time.
Thanks so much. Take care.
You as well. Bye-bye. Greg Jarrett is a Fox News legal analyst, former defense attorney and law professor, and author with some incredible books.